Hey everybody, and welcome to our Estate Planning Explained series. Today we're going to be talking about wills. My name is Jeff Althaus and I'm an attorney at Althaus Law. We get a lot of questions on wills and what's the difference between a will and a trust, and we're going to go over a lot of that today. A will is really just a stack of papers that says where you want your stuff to go when you pass away. Now, a lot of people think when they have a will they get to avoid this scary process called probate. And that is not always true. So if all you have is a will, you're not going to avoid that probate process. You need a little bit more planning if you have real property like a house, land, mineral interests, or a set amount of assets in whatever state that you're in. In Colorado this year, it's $68,000. If you have more than that, you're going to probate. If you have less than that, you don't have to. So in your will, basically, you say where you want all your things to go in that probate process. The difference between a trust is that it can very easily avoid that process. However, there is a way with a will to still avoid probate. And I won't get into it in too much depth here because we're just going to focus on what a will actually does. But if you have this little document called a beneficiary deed, which we'll do a whole nother video on, it can actually help you avoid probate with a will. So back to the basics of a will. It's just a stack of papers that says where you want your stuff to go. You also name who you want in charge of the show when you pass away. That person is called your personal representative. If you've ever heard the term executor or executrix, they're all the exact same person. They're in charge of that probate process. So you name someone here that you trust to do one of four things. Well, actually, they're going to do all four things, but they have to find all your assets, they have to value those assets, they have to pay any creditors, and then they have to distribute everything per the terms of your will. Once they do that, they're done, and they're done with the probate process. It may sound simple, but it can take up to 6 months to a year in Colorado, maybe even longer if people are fighting. In other states, it can be even longer. The other thing you can do in your will, and this is very, very important for all you parents out there with minor children. I try to beat this into people's heads as much as I can. You can name a guardian for your minor children. I cannot stress enough how important this is. Naming a guardian is one of the only ways to stop foster care. And it really just says, if you can't be parent for your child, who's going to be mom and dad? If you just have named someone as a godparent, or you have a verbal agreement with someone, or you just think, hey, they'll figure it out, my family knows who I would want to do that, that's not going to hold up in court. A judge will just have to guess essentially on who you would want protecting your kids if you can't. In your will, you name that guardian, so you're deciding now, and then the judge will follow it later. So hands down to me, the most important thing parents can do in an estate plan anyway for their minor children. Once the kids are over 18, sorry, you can't give them away anymore. I can't help you there. But that's really a will, and that's all there is to it. You say where you want your stuff to go, you name a personal representative, and you can appoint that guardian for any minor children. So if you want to know any more information, feel free to check out our website, any of our other videos on our Explained series. But thanks for listening. Jeff Althaus at Althaus Law. See you later.